Welcome. Please request only the time that you need, not the time that you wish. There are over 7 hours of argument time requested, and if we have further questions, we will keep asking them, and we are familiar with the briefs and the records in each case. People versus Bladen, appellant. Respondent? 4-1 and 4. Hart versus Kappa. 5 and 5. J. Darren versus Sandra R. is submitted. People versus Hood, appellant, submitted. People versus Johnson, appellant, submitted. Barone versus Barone, submitted. Smith versus Global Contact, appellant. Are you the appellant or the respondent? Do you wish to submit, or do you wish some argument time? Okay. Smith versus Global Contact is submitted. People versus Dubose, appellant, submitted. It's going to be quicker than we thought today. People versus Flores, appellant. 4-1 and 4. Maclo Investment versus NYPD, appellant.
5 minutes and 2 protocols.
Respondent? 5, 2, and 5. Cherie is submitted. Moises Ortiz versus FDB Acquisition, appellant, first appellant. Appellant 2. And appellant 3. 6 and 1, 5 and 2, 5 and 2. Henk Lane versus Stallard Management, appellant. Does not look like there is any respondent. Are you respondent?
Yes, I filled out the form.
No, I just didn't see you stand up.
Oh, okay, I'm slow, I apologize. I would also like 10 minutes.
I will give you 6, 1, and 6. Again, if we have any further questions, we'll keep asking them.
I'll take it, thank you.
People versus Ali is submitted. Sanchez versus New York City Medical, respondent. Okay, you didn't request any argument time.
I know that, Your Honor, was a formatting error, so it's all good.
Respondent?
Respondent 2 minutes, Your Honor.
2 and 2.
Thank you, Your Honor.
Stallard versus New York City Police Department, appellant.
Commissioner Appellate, we have 16, please.
Respondent? 5 and 5. Brit versus MTA, appellant.
6 and 2, Your Honor.
Respondent? 6, 2, and 6. People versus Vasquez is submitted. People versus Lucant, appellant.
For appellant 6 and 2, please, Your Honor.
Respondent? 5, 1, and 5. Valley National Bank versus 252 West 31st is submitted. Aguilera versus City of New York is submitted. Norgard Insurance versus 140 West is submitted. And People X-Rail Sajeda versus Honorable Lippman is submitted. So our first case today will be People versus Bladen.
Good afternoon, and may it please the court, I'm Steve Moralia for appellant Mr. Bladen. The motion court erred in summarily denying the motion to controvert the search warrant and to suppress the evidence obtained as a result of the execution of the warrant. This was a case involving a confidential informant, so much of the warrant was redacted, and the appellant was unable to, as a result, be too specific. But the court did make a determination and issued a final order denying.
Let's say we assume that you are correct, that we should consider the issue on the merits. I guess you can't really address the merits because you haven't seen the search warrant. You're asking to see it. So is there any argument you wish to make on the merits? Assuming we agree with you that we should look at the merits of it.
Yes, I mean, I would just ask the court to do all of the kinds of things that the Court of Appeals has said, that courts monitoring these kinds of warrants that are confidential do. Look at it from the perspective of what the defendant would question. Was the information timely? Was it specific? Was it particularized enough? All of the kinds of concerns that one would have in analyzing a warrant to see whether the issuing court had before it information that would provide probable cause to believe that there would be contraband, the proceeds of a crime.
So, counsel, there was a warrant application, right? There was a hearing on the warrant application below.
Yes, exactly.
And all the information that you're asking us to look at was looked at by the trial court, right?
Yes, we're just asking this court to in camera review the materials that have been submitted by the people to make sure that the warrant was properly issued upon sufficient facts to establish probable cause to believe that a crime had been committed in that location and that the proceeds.
And we start with a presumption of validity, right?
Yes.
We start with a presumption of validity, and then we just look and see if there's any clear kind of error or something that the trial court missed.
Look whether on the face of the warrant, within its four corners, the information presented to the issuing court was sufficient to allow it to reasonably conclude that there was probable cause.
But what distinguishes this from every other case where the presumption of validity exists? Why is it that on this case we should examine it on that level? Because otherwise, if there's no special factor, then we'd be examining every warrant application.
Well, as the Court of Appeals has said, and this court has said, this court has an important role to play in monitoring the warrants and whether they are issued on probable
You have the
cause.
right to have us look at the warrant and make sure everything is proper. We will do that.
Yes, thank you, Your Honor.
Okay, thank you.
Good afternoon. Kate Trefon for the respondent. If it please the court, so there was a waiver of appeal, a valid waiver of appeal that forecloses this whole issue. But even notwithstanding the waiver of appeal, defendant forfeited with his plea of guilty when he pled guilty before the Darden hearing was held. So there was, at best,
But didn't the court issue a ruling where the court expressly denied his motion to controvert the warrant?
so
Wouldn't that bring up for us for review, assuming, putting aside the waiver issue, wouldn't that bring up for us to review the ability to search the warrant and make sure it's proper?
So at best, Your Honor, it's the decision from the court, the written decision regarding the controverting the search warrant was 2 sentences, and then there's this discrepancy.
The court definitely did make a determination, and it definitely denied the motion.
The court said he found the warrant that was based on probable cause. However, then the court also ordered a Darden hearing.
Yeah, but the Darden hearing is just to see, just to make sure that the information that was withheld is proper, right? So that's not good. That doesn't change the fact that the trial judge made a decision on the warrant.
But then it begs the question, if the Darden hearing was held and the information wasn't sufficient, what would the court have done? So it's just,
I guess it would have vacated its earlier order, right? But there is an order.
there is an order. I will say, and this is my final thing on this because we can move on, that in pleading guilty, defendant precluded the continuation of a record, right? So that's why we're having this conversation, because we don't know what the court's order, there was a discrepancy there, or at least a tension between ordering the Darden hearing and finding probable cause. That being said, the warrant was based on probable cause. The Aguilar-Spinelli test was met by the detective's affidavit. So even though the magistrate didn't hear from the confidential informant, did hear thoroughly from the detective who gave the evidence, the warrant was supported by probable cause. The search was good. So there is no reason for your honors to review the warrant. And if there are no further questions, I would rely on my brief.
Thank you very much.
Thank you.
Yes, just very briefly, to the extent that there was any kind of forfeiture by the guilty plea, it only forfeited any kind of arguments that there would be going to whether the confidential informant existed and all that kind of a thing. Based on the order that we have, the final order, that's why I specifically limited my request to looking at the four corners of what was presented to the issuing court, because any questions about, the truth of the thing, of all that was forfeited. I would concede that. It's just on the face of it, within the four corners of the information presented to the issuing court, was that enough for that court to issue the warrant on probable cause?
Thank you.
Very narrow question. Thank you.
Hart versus Kappa.
Good afternoon, Your Honors. If it may please the court, my name is Matthew Conroy. I represent the plaintiff appellant, Penny Hart, in this matter. I will be relatively brief, despite the size of the record in this case. As the court, I'm sure, is aware, this was a partition action that involves two large apartments that were combined on Grand Avenue.
So this went to a referee. I mean, this went to a referee to determine what the split should be when the apartment was partitioned, right? The judge sent it to a referee?
It did, but that was the result of in order, post-bench trial. There was a trial on the...
Yeah, and that was
partition
appealed,
Exactly.
and
It was
several
sent-
judges
it was
here
sent
were
to
on
the
it.
referee, submissions were made, there was an appraisal, and the referee made certain findings and made a report. The court adopted that report in full.
So why should, I mean, the referee heard the witnesses and looked at the testimony and was able to judge everything and wrote why he came to his conclusions. On what basis should we set that aside?
So Your Honor's pointed it out exactly. The referee, in fact, just took submissions on paper. There was no testimony taken. There was no hearing had. The referee simply took written submissions, which included most of the record from the underlying appeal and the decision in order of the court, which made factual
Isn't that
findings.
typical, though, for those kind of hearings?
Is it typical?
Before referees?
Well, the referee has the powers under 4317 to conduct an evidentiary hearing, to request additional records, to
If it
take
needs it.
testimony. He did not.
If he or she needs it, it's not required to have a hearing.
If necessary, certainly, but when the report is then given to the trial court has discretion to look at that, adopt it in full, in part, in none, order a further hearing,
And why didn't
make
that-
additional findings.
Isn't that exactly what the court did in this case?
The court did not do that. The court essentially adopted the full findings of the referee.
But counsel, wasn't the referral for an accounting? It wasn't really for a full analysis, but the Justice Klein's order dated October 5th at page 7 says this matter is referred for an accounting.
Well,
So it doesn't, and it seems to me in the typical case that accountings don't usually involve a factual hearing, especially where Justice Klein's had already held a factual finding and made findings, had already held a factual hearing and made credibility findings. So the referral was really just for accounting purposes. So in that circumstance, it's not uncommon to do it based on the documents, right?
Right. So the order is on the record at page 41, and the referee was appointed to review the party's accounting of and concerning the acquisition, maintenance, debt service, mortgage carrying cost, and renovations, and to then file a report and recommendation as to the respective rights. The problem, of course, is that the referee made factual findings and made determinations of credibility.
What is it that you think is wrong? What specifically are you arguing is improper about the referee's determination?
So there were two primary things. One is a matter of law, and that is the issue of moiety on the credit for the down payment on the first unit. What happened, and this is supported by the record, Ms. Hart deposited roughly $1 million into a Vanguard account with Mr. Kappa, which they then owned jointly. She withdrew $348,000 or so and put it into her personal checking account, and then used a check from her checking account to pay part of the purchase price for the first unit. The referee took that $348 and split it in half, saying that money
Didn't
came
they
from the
own
joint
that
account.
checking account as jointly with right of survivorship?
No. The Vanguard account, the original account where the money came from, Ms. Hart had put in $1 million.
I'm asking you how they owned the account.
The Vanguard account was joint.
Right, so that account is joint with right of survivorship.
It was.
Which means that each party owns half of the account, right?
Yes, but when
So where is the error here?
when one party withdraws part of it, less than half, that's referred to as a moiety, and I quote it in I think it's called the Bricker versus Crimer case, and it essentially says that breaks the joint tenancy. If it's more than half, under the rules of moiety, that joint tenant is obligated to the other joint tenant. It's still good law. It was cited by Justice Knock in 2004 in a case in this department, but that's Bricker versus Crimer, 1963.
Thank you. Thank you very much.
Thank you, Your Honors.
Good afternoon, Your Honors. My name is Mary Margaret Luby, and I represent the respondent, Thomas Kappa. I believe that the lower court got it right, correctly adopted the report of the referee, and the referee had, despite what counsel states, the referee had all the evidence in front of him in order to make a determination. Not only did he have the accounting of the parties, but he had literal testimony that was from the trial. Now, part of the argument that that Ms. Hart makes is that the referee had no ability to judge the credibility of the witnesses of either Hart or of Kappa because they didn't testify and come before him. However, one of the main issues that they discuss in their brief is the renovations of the apartments. I paid $1 million towards the renovations. I paid $300,000 towards the renovations. But in the transcript at trial that the judge saw, the referee's report after, he was there. Everything was bait stamped. Ms. Hart testified at length all about 99% of the checks that she later submitted to the referee without a bait stamped, switched her testimony saying, oh, these are for the renovations.
Well,
And Justice Klein's made very specific credibility findings with regard to the testimony he heard, right?
Correct. And so did the referee after he saw that all of the submissions by Ms. Hart in the accounting contradicted her testimony at the trial.
It seemed that maybe both of your clients were not the best record keepers during this period of time, to make an understatement. And it appeared that one of the concerns the referee had was he looked at everything and he felt that nobody really sustained their burden of proving what they were trying to prove, so it made it very difficult.
Correct, Your Honor. And one of the benefits that Mr. Kappa had was the use of the trial transcript and the evidence and the testimony that Ms. Hart used. Ms. Hart, even with the redemption that was used to purchase, and I understand the case law that counsel is using, and I don't believe that applies. That case talks about an incompetent and switching the accounts, and in that particular case, They gave the money, the incompetent had a joint account with her spouse, and he ended up transferring that money to his son, and then they wanted to get it back. The redemption occurred because Mr. Kappa took the money out of the joint Vanguard and gave it to Hart, and she deposited it into her account. Nowhere in the testimony at trial, and even in the accounting, did she ever say that she took the money out herself. It was for the joint ownership of the unit.
Thank you very much.
Thank you.
Thank you both. People versus Flores?
May it please the court, Maya Stevenson for Alexis Flores. Your Honors, this court should reduce Mr. Flores' sentence because it is both unduly harsh and excessive for several reasons. First, Mr. Flores is a first-time offender who has not otherwise interacted with the criminal legal.
Let me ask you before you get into that, wasn't there a valid waiver of the right to appeal here which would foreclose the argument that you're making?
Your Honor, Mr. Flores' appeal waiver was invalid because it mistakenly implied that he was waiving his right to appellate counsel, and it was procedurally unsound. As I was discussing, Mr. Flores is a first-time.
No, wait. What do you mean he was? I mean, that looked exactly like the CJI.
Yes, Your Honor.
So are you saying the CJI is inadequate and not good?
No, Your Honor, I'm not.
So tell me how, have we ever held that a waiver that complies with the CJI is invalid?
No, Your Honor. This
Okay,
court
so
has-
where are we at here?
Your Honor, there are several factors in this case that make Mr. Flores' appeal waiver invalid. First of all, Mr. Flores was 20 years old at the time of offense and 23 years old at the time of sentencing, and he was a first-time offender, demonstrating that both his age and experience, which are meaningful factors that this court considers when examining the validity of a waiver.
Did he go through the waiver with his attorney?
Yes, Your Honor.
Did he have an attorney that he had, was available to him to ask any questions that he wanted?
Yes, Your Honor.
And did he explain on the record, and was it on the record that he went through this with his attorney?
Yes, Your Honor.
So yes, he was not 40 years old, but again, how does that affect the waiver?
Your Honor, beyond Mr. Flores' age and experience, which were both meaningful factors that this court should consider in terms of the validity of the waiver, the language of the waiver was also procedurally unsound. The waiver that was given by the court under the CJI implied that Mr. Flores was operating in an abnormal situation where he would not be entitled to appellate counsel, and the written waiver further compounded that error by using meaningful or similar language that would imply that Mr. Flores was being denied his use of appellate counsel in the future. Both of these things demonstrate that Mr. Flores was not adequately appraised or had a full understanding as necessitated by the Court of Appeals of his.
Use your remaining time to address the merits,
Yes, Your Honor.
since we're running out of time.
Mr. Flores' sentence is also excessive because it is both unduly harsh and excessive. He was 20 years old at the time of the incident, 23 at the time of sentencing, demonstrating that, as the Supreme Court has held several times, his brain was not fully developed enough to understand the full consequences of his actions. And while he did commit a horrible crime, which he took full responsibility for, Mr. Flores is not a hardened criminal who deserves 22 years in prison. Further, there are several or no aggravating factors present in this case as compared to other cases across appellate courts in New York City where similar sentences have been upheld. In People v. Buck out of the Third Circuit, there was a defendant who shot over 20 times in a hostage situation where both his father and young daughter was present, and even that defendant only received 20 years. Here,
Well, he was charged originally with second-degree murder,
yes, Your Honor,
and he pled to,
manslaughter in the first.
so his possible sentence was 25 to life, correct?
Yes, Your Honor.
And he got 22 with some probation period, right?
Yes, Your Honor.
So that's quite a, I mean, that is quite of a difference, right? 25 to life to a determinate sentence, no?
It is a difference. However, Your Honor, it is still not a sentence that Mr. may I finish? That would adequately or is necessary to deter Mr. Flores from criminal conduct. Mr. Flores was an adolescent essentially in his brain, and he is not a hardened criminal.
Thank you very much.
Thank you.
Good afternoon, Your Honors. Andrew Loizides appearing for the people and may it please the court. Your Honors, the defendant validly, knowingly, and intelligently waived his right to appeal, thus precluding him from being able to raise the issue on appeal as to whether or not his sentence is excessive. But regardless of that,
Yeah, he's a first-time offender, right?
yes, Your Honor.
Where did this number come from, 22 years?
Your Honor, that was taken into consideration the fact that he did, in fact, kill a person for no reason at all.
At close range, with a gun.
Yes, at close range, outside
And
of it.
also, it was 3 years before he was apprehended. I mean, it wasn't like he, she said he admitted his guilt, but it was 3 years before he was
That's correct, Your Honor. Yes, in fact, actually, after the incident, he fled from the scene, and the law enforcement wasn't able to find him for 3 years. And then he was arrested, and as we mentioned before, he was charged originally with murder in the second degree. Where
Isn't his disappearing for 3 years somewhat consistent with counsel's argument that he was operating as an adolescent would as opposed to an adult?
Well, Your Honor, he wasn't. This is not some youthful indiscretion, Your Honor. I mean, at 20 years old, I think people ought to know that killing someone is wrong, and that they should, be in that.
Doesn't the social science literature say that at age 20 that many people are still acting more like adolescents than like adults?
I think that in that instance, I don't think that's entirely the case, Your Honor. But even still, even if that were the case, I think that even an adolescent would also know that killing someone is wrong. And also, this defendant was not tried as an adolescent. He wasn't tried as a juvenile offender. He was tried as an adult. He was arrested. He committed this crime when he was an adult. He was tried and sentenced when he was an adult. His actions are that of an adult in this instance. And as I mentioned before, Your Honors, that alone would show that he knowingly, voluntarily, and that he waived his right to appeal. And given the nature of the offense here, his sentence is not excessive. And unless Your Honors have any further questions, I respectfully submit on my rest of the arguments on the brief.
Thank you.
Thank you.
Your Honors, while it is certainly true that Mr. Flores did kill a person in this case, which he took full responsibility for.
So could you say, honestly, did he? Because he fled and it took him 3 years to find him, right? So he didn't really come up. He didn't, the next day, go into the police precinct, surrender himself, did he?
No, Your Honor, he did not.
And unless they found him, he wasn't going to take responsibility for this, correct?
Your Honor, I'm not sure that's the
Okay,
case.
that's fair. Who knows? You're right. You're correct.
However,
But for 3 years, he didn't take responsibility.
Yes, Your Honor. However, that's indicative of Mr. Flores' brain not being fully developed. He was operating at the brain development of an adolescent, which was not able to fully appreciate the consequences of his actions or ignore his impulses. And while that is no excuse, Mr. Flores has taken full responsibility for what happened in this case, which was a tragic circumstance.
So there was no evidence presented by your office with regard to the particularized developmental state of this defendant, correct?
No, Your Honor, we do not have that on the record.
Thank you very much. Maclo Investment versus NYPD.
Good afternoon, Your Honors, and may it please the court. Richard Trotter of Feuerstein Kulik on behalf of the plaintiff appellant, Maclo Investment Properties. As I'm sure Your Honors are aware, this appeal concerns a decision by the IAS court entering summary judgment in favor of the respondents.
Counsel, let me ask you a question. The agreement is pretty clear in its language, and it clearly does say that there shouldn't be any commission paid unless Maclo executes a leasing commission agreement. And it's undisputed that Maclo never did execute one in this case and never even presented one to defendant to sign. So how to get around that one was never even presented despite a request being made for one to be presented.
Thank you, Your Honor. You're correct. It is undisputed that no leasing commission agreement was signed. However,
And it's undisputed that they never even gave a proposed one.
respectfully, Your Honor, the agreement, I think, is ambiguous with respect to who's required to present it. In fact, in their brief, the respondents acknowledged that all Maclo was required to do was execute a leasing commission agreement, and that either the owner of the property or Maclo, acting as the broker, could have presented the leasing commission
But that
agreement.
doesn't matter who was supposed to produce it. The fact is, you agree that he had to have executed it, which he clearly didn't.
Well, that's
He
correct.
could, I mean, notwithstanding what you claim is ambiguity in the language, he could have produced it and executed it and chose not to.
Right, he could have, that's why it sounds so weak what you're saying, because it's one thing that said if they presented 20 agreements, I presented 20 agreements, they would never sign any of the agreements, I kept working with them, and they refused to move forward. But that's not what this record is. It's to the contrary, there was never even a draft sent by the plaintiff of an agreement.
Well, respectfully, Your Honor, the relationship between the parties was somewhat unique here. It was not the typical broker-owner relationship. The Phillips lease, which was for $121 million at the commercial section of the property located at 432 Park Avenue, which is owned by the respondents, played out over many years. And so there were quite a lot of back and forth between the parties. And it's worth mentioning that there is absolutely not a single piece of evidence in the record that anyone on the behalf of respondents ever noted or requested the execution of a leasing commission.
That doesn't matter. The agreement says that there has to be an industry standard leasing commission agreement. So if your client wanted to get the fee, it was up to your client to take the steps to make sure a record was established, that it took all efforts to make that happen. It wasn't on the defendant's burden to keep sending you things and encourage you to sign. It was your burden or your client's burden to make sure that happened.
Well, respectfully, Your Honor,
So it was frustrated.
we believe that Maclo did do everything possible to make clear its intention to be paid the commission. So the record on this is
But
clear.
even if they did that, I mean, we keep going back, I think, to the same thing. The contract, the agreement is pretty clear that you could get paid if you had this industry-approved document signed. So whether you present it to them or they presented it to you, the record shows that nobody presented anything to anybody, so it never got signed. How do you get by that?
Well, respectfully, Your Honor, I disagree.
Even if their intention was different.
I disagree with your last point that nothing was presented to anyone. So the record shows in emails that in November 11th, a month before the lease
I
was
saw
signed,
the emails.
Maclo said to the owners the exact dollar amount of what they expected to be paid and that they expected.
full
The
amount.
condition,
I'm sorry?
Which was the full amount. So
Correct.
they
And
wanted to be paid the full amount.
the full amount upon execution of the Phillips lease. For 4 weeks, respondents said nothing. They
But
made no
silence,
condition-
the law says that silence isn't good enough to win this case.
I understand that's respondent's argument, Your Honor, and I agree with you. There is case law to that effect. However, I would submit that it was not mere silence here. The respondents asked Mr. Maclo, right, as the broker, to populate the below with real figures. In other words,
but the condition precedent wasn't that they expressed an intention to sign a commission agreement. It was to have executed one, and that didn't happen, right? So how is that satisfied by whatever good intentions your client had?
I would not submit that it was satisfied in accordance with the language of the agreement. What we argue is that it's a question of waiver. Waiver is fact-intensive. There is substantial evidence in the record to indicate a
Who are
materially
you saying waived your?
a waiver of the condition precedent. That
Right,
was-
but if you had sent a draft, your client had sent a draft and saying, this is a draft, we want full payment, we are not willing to negotiate on this figure at all, we want full payment, and this is a draft of the leasing commission, if you don't sign it, we will consider you to be in breach, you'd have a much stronger case, but none of that is in the record.
Well, there is a draft of the commission agreement that was presented by respondents. We refer to it as the proposed commission agreement.
That was
They
where they're,
presented it.
Right, but which, yes, but not with respect to the question of who presented it, but rather it showed that there was a dispute with respect to the amount owed, and that no leasing commission agreement for what Maclo believed it was entitled to, in which it had informed respondents of prior to signing the Phillips lease, that was not going to be reached, that it was effectively
Let's hear
futile.
from,
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. My name is Megan Rowe of Herrick Feinstein on behalf of defendants' respondents. I think it's clear from the record that the April 2017 letter agreement addressed multiple property management issues between the
Well, let me
parties.
ask you something. Plaintiff made clear pretty much at the beginning that they wanted full payment. Wasn't that enough to show that it would have been futile to send a proposed commission agreement since your client indicated they weren't willing to make full payment of the commission?
No. What's, I guess, nice about condition proceedings is that they're very straightforward. This is in the agreement. It's no surprise. There's clear language that says if you want to get paid a commission, you must satisfy this condition proceeding of a leasing commission agreement. In this case, there were 3 brokers who had worked on this deal, 2 of which actually closed the deal, that was not appellant. The 2 other brokers who got paid both executed proposed leasing commission agreements.
So there was a letter that came out in 2019, right? That's in the record, where they said, yes, there were 3 leasing agents that dealt with it, and we were gonna pay this one this, and this one that, and didn't they make an offer, even though there was no agreement, didn't they make an offer to pay Maclo something, part of the commission?
So I believe,
Like $1 million or something
I
like
believe what you're referring to, the 2019 letter agreement, it's actually a settlement communication. We briefed it in our papers. This was, I believe it was October 2019,
Right.
so after this dispute had been going on for about a year pre-litigation. That was a communication from respondents to resolve both the leasing commission issue and then other issues under a joint venture agreement, which is outside of this record and a completely separate issue between the parties because they did have a unique relationship. That's a settlement communication. It should not be considered at all. And I think it's clear that's a settlement communication, one, from the fact that the first paragraph in it notes that Maclo's, I can quote to you from it, Maclo's position is X, that they are owed a certain agreement. Maclo broker's position is that pursuant to the agreement, they're entitled to receive X. Investor's position is X. There's also a release contained in it. It's very clearly a settlement communication, even though it wasn't sent by Eric Feinstein to appellant's counsel or something like that. It should not be considered at all. To the extent that it is considered, it's clearly not a proposed leasing commission agreement. There's no representations and warranties in there that would be in a leasing commission agreement. There's no indemnification related to the other brokers that worked on this deal. It's completely dissimilar to the leasing commission agreements that were executed in this case. They're in the record, both in the expert reports that are in respondent's appendix and then also in appellant's papers that are from CBRE, that are from Cushman, and there's other examples in the record. It's not a proposed leasing commission agreement. In here, the condition precedent requires that one be executed to be
What's your
paid.
response to the waiver argument, that there was a waiver based on the actions in this case?
There was no action by respondents. Mere silence is not enough. Appellant said that it wanted to get paid. It did not receive any response from respondents as to payment. They did not send a leasing commission agreement to get paid. I think this court is correct in noting that if this was a case where appellant sent a proposed commission agreement and it was negotiated or not negotiated, we would have a very different case in front of us. But on the facts that we have before us, the appellant cannot argue and the court cannot see what would have happened if appellant sought to comply with the condition precedent because no effort was made whatsoever. Thank you. If the court has any other questions, I'm happy to answer them. Otherwise, we respond to our briefs.
Thank you.
Thank you, Your Honors. Just a few quick points on rebuttal. There's a well-established principle of waiver law that a contractual party cannot lull the other into a belief that a condition will not be enforced, only to try and enforce it later on. In our view, the record shows that's precisely what happened here. Specifically, at page 209 of the appendix, there's an email from the respondent's principal flagging 6 months before the Phillips lease is signed this impending disagreement over the amount of the commission. He says that
Did you get that email?
I'm sorry?
Did you get that email?
Did we get that? No, it's an internal
So
email.
how could that be, how could that have lulled you into anything? You didn't get that email.
No, I mentioned that email to show.
No, you have to show how you were lulled. What was sent to you that lulled you? Not that they spoke about internally. What did you get?
Yes, Your Honor, that's a separate email which Mr. Brill Edwards sent on November 11th, 2018, a month before the lease was signed, saying that this is the commission, $3,093,125 that Maclo expects to be paid upon the execution of the Phillips lease.
So that's, again, you said that, correct?
Yes, but it was
So
in
that how you can't be lulled by your own actions. Again, I'm going to ask you, what did the defendant send you that lulled you into believing you were getting your full commission?
Respondents sent, Mr. Bakos, the principal of respondents, sent an email saying that he would have to run the amount of the commission by the owner of 432 Park and asked Maclo to, quote, populate the below with real figures.
Did that ever happen?
Yes, that did happen. In the email that responded the next day, Mr. Brill Edwards said, I mean, this part of it was quite contained. Mr. Bakos said, how much do we owe you, effectively? Mr. Brill Edwards said, this is how much you owe us, $3,093,125. And you owe it to us upon execution of the $121 million Phillips lease. Nothing. Silence, then execution of the Phillips lease, taking the $121 million benefit and not paying any commission whatsoever. To your Honor's question, that was the lulling.
Thank you.
Thank you.
Moises Ortiz versus FTB. Go ahead.
Thank you. May it please the court, Michael Prisco for the plaintiff.
If you could speak up a little.
Michael Prisco for the plaintiff. This court should grant the plaintiff summary judgment on the 240 claim, affirm summary judgment to the plaintiff on the 241-6 claim, and affirm the
Let me
denial.
ask you something. The court below very specifically based its decision on its finding that a brace is not a safety device and based it on the Court of Appeals decision. What is your response to the position of the court below that you're not entitled to summary judgment, your client's not entitled because the Court of Appeals has specifically held that a brace is not a safety device?
So, Your Honor is referencing the Maserati case, which is clearly distinguishable under the facts of this case.
That's what I'm asking you,
Yes.
how it's distinguishable.
It's distinguishable because in Maserati, unlike here, it was a completed firewall, and there was no particular or peculiar or foreseeable risk associated with that. As this court held after the Maserati case in two separate cases, for example, the Purcell case, this court held that a terracotta wall that collapsed near a worker who was working, removing a brace, and this wall collapsed on him, that particular wall, because the foundation it was sitting on, it was not braced or shored in any way, and that represented a particular and foreseeable gravity-related risk that made it different. And the court specifically even referenced Maserati in its decision, differentiating between the two. Maserati, it's a completed wall. It's an ordinary construction risk that this wall could have possibly fallen. It's not very foreseeable that it was. In the Purcell case, this terracotta wall was, and the defendants—
Let me ask you something, because one issue is foreseeability, which clearly comes in when it's a fixed part of a building that falls. But does the issue of foreseeability, of lack of foreseeability, how does that interact with the issue of the requirement that there be a safety device that was not there?
I think the issue of foreseeability is intertwined with whether a safety device as enumerated by the statute should be deployed.
But the building next door was there, right? You're arguing they didn't have a brace on the building next door. It was a completed building next door, correct?
That is correct.
So then, that's what I'm saying. When you're saying the terracotta wall, how is this different then from the Court of Appeals case? A finished wall, no brace. Here, finished wall, no brace. How is it different?
Because under the circumstances here, based upon the whole visual inspection, there was a cold joint directly above the plaintiff who was in a pit 14 feet below, And as the defendant's expert said, the era that this foundational wall was constructed was at a time where they didn't reinforce the cold joint with rebar. So there was a particular risk in this case, a very foreseeable risk, that this cold joint could dislodge, as happened here, and fall onto this plaintiff below.
So is part of the distinction that you're drawing the fact that where the plaintiff was injured was way below ground level, and that created different risks of foreseeable to injury than if he'd been at a higher level?
I think absolutely. He's in a pit 14 feet below, and as the defendant's expert specifically stated at 260 in the record, paragraph 31, the cold joint that dislodged was, there was a photograph taken about 2 days before, a couple of days before, that showed this particular cold joint in a deteriorated nature directly above this particular pit that plaintiff was going to work in. And now this was the last pit during this undermining process, right? They didn't just create a pit around the whole foundation and begin to underpin. It was done in sections, and this was one of the last sections being done, and it was clearly foreseeable, given the nature that he's down in this pit, the cold joint's directly above, that this cold joint could dislodge and fall on the worker. And that's why it makes it much different than the Miserati case, which is just a completed wall and just an unfortunate accident that was ordinary to a construction
They had
site.
just demolished the building that they were there, they were going to build a new building, and that's why they were working on the foundation. Wasn't this building right adjacent to the next building? So they took it down. Wasn't there a plan by an outside expert company that said there has to be all this underpinning and all this work because it's foreseeable that something could happen as you're building farther down on the foundation? They were creating a deeper foundation than had been there before.
That's correct. The purpose of the underpinning is because as they're going deeper down on the building, their construction, they need to stabilize the foundation of the adjacent building. But in addition to that, based on the visual photographs and inspection by this consultant, RA, per the defendant's expert, they should have seen other risks associated with this work. In particular, up above where these pits were, there were cold joints, and as the defendant says, at 260, paragraph 29, this foundation up above was constructed, the cold joints were constructed during an era when concrete footings did not incorporate steel reinforcing bars, because the defendant in the case, I see my time is up, if I could finish my one point.
Finish your sentence.
Yeah, sure. The defendant in this case, the project manager, testified that we could have known if there was a key joint there, but we didn't see one, but we would have no way to know there was rebar in this joint. But that's in direct contradiction to their own expert's affirmation, where he says this particular foundation was built during an era where they did not use rebar for the cold joints.
Thank you.
Thank you.
Good afternoon, Your Honor. Christian Gannon on behalf of Appellant Respondent FDP and Pavlak. Your Honor, I think a way to lighten the load of the Appellate Division of writing an opinion is to focus on the fact that on two of these issues, the 240 and the 1.7a, were decided sua sponte in favor of the non-moving defendant. That is not appealable.
Right, but we still have to address the issue. Plaintiff is appealing the denial of his motion for summary judgment on the 240 case. So we have to, even if we decided that we shouldn't be addressing the sua sponte aspect of the termination, we have to address the merits of the 241 case in order to determine whether or not the court correctly denied plaintiff's motion for summary judgment.
Fair enough, Your Honor.
I mean, we're happy to not address an issue, but we have to address.
This is my suggestion. So, Your Honor, I think in the 240 case, 240, broadly speaking, is addressing cases with falling workers or falling objects. This situation, the plaintiff was not in a situation where he was at a level where he was subject to a fall. He's working on the ground.
Clearly it was a falling object case. I mean, the
well,
enormous piece of concrete fell on him.
But Your Honor,
it's below it. So.
Not a traditional 240 sense, because this is a permanent structure. There's no enumerated device under 240 which addresses this situation.
Counsel, Hasn't there been a lot of cases that have addressed the issue of permanent structures, and when a permanent structure, something that falls from a permanent structure can or cannot amount to a 240 case, and it's normally is analyzed in the issue in terms of the issue of whether or not something is or is not foreseeable. And in fact, below, the court decided on one thing, but that wasn't what the parties were arguing. The argument below was centered around the issue of foreseeability, and normally the idea is that when it's a permanent structure, it's not foreseeable that something's going to fall off a permanent structure. But isn't there, in this particular case, a tremendous, and I know I'm asking a lot of questions, but a tremendous amount of evidence that it was foreseeable based on the circumstances of this case that something was going to fall off this thing which had not properly been underpinned?
Well, the foreseeability question, Justice Leibowitz said that was a question of fact. He said that himself in his opinion, but he dismissed the 240 because he said this was not a situation in which a hoisting or securing device of the kind enumerated in the statute would have been necessary or even expected.
So what evidence is there in the record that it was not foreseeable that this could occur based on the particular circumstances of this case where they had taken away the underpinning of the other building and they were all focused on the issue that this was a real risk, that the underpinning was not there and that something could fall? How have you brought forth any evidence to raise an issue of fact as to the foreseeability?
Two ways, Your Honor. All the witnesses from FTP, Pavlak, RNC said they had never seen this happen in their career. They've been on multiple excavation projects like this with underpinning.
But the fact that it's never,
I'm sorry?
that they hadn't seen it in their careers is not necessarily a relevant criteria for determining whether it's foreseeable.
They also
given
said,
these particular circumstances. We don't know whether their career ever involved a worker working on a level of a foundation several significantly below an adjacent building in which the foundation was built with what we now consider inadequate support.
yes, Your Honor, a couple things. First, if you look at the photographs, the plaintiff is not working significantly below the foundation. In fact, it's just above him. If he's lying on the ground, it's literally within a few feet of where he is.
But I mean, you know that the cases say a few feet can be a significant difference also. And I just want to add in a little bit, if you don't mind, to Justice Gesmer's question. I thought that the plaintiff submitted as in the record and to the trial court an expert affirmation from an expert that was hired by you, Mr. Spivey, who was an engineer. He was engaged by you when you were opposing a motion by RA seeking summary judgment that basically said that maybe, there was some problems here that was foreseeable and there were a lot that these issues should have been addressed before the plaintiff was standing in a pit working on the building. So you got an expert, your own expert, who, says those things. How do you get around that?
Well, Your Honor, first of all, not my expert. It was RNC who retained.
I thought it was you and RNC.
I FTP and RA. But I think the reason the lower court found a question of fact is because plaintiff's expert says this just based upon looking at it, which I don't think is sufficient. There was no testing of it or whatsoever. And Mr. Spivey looked at it. He's talking about the means and methods of this consultant and what they needed to do, what they should have investigated to determine whether or not it was actually compromised or foreseeable for collapse. So there's nothing in the record to show by looking at it this thing was going to collapse. It's a question of fact, and if it goes that way, it's a matter of these two experts battling out as to what should have been done based upon testing of the site.
May it please the court, Brendan Fitzpatrick, counsel for RNC. Yes, we hired Mr. Spivey. Just to quickly address a couple things on the 240 issue. I believe Mr. Perez, he's been very, very experienced with excavations, underpinning, and he specifically testified in the 14 years he's been doing this, this has never happened. This was essentially a latent defect that no one could have seen. No one had ever...
That would have been latent when there was so much discussion in the record that based on the particular circumstances of this case with this older building that didn't have the normal standard safety features in it that now exist, that this was a risk and a problem that it needed to be addressed. So How can you reconcile what you're saying with this record?
Because that's all from Mr. Spivey, and that's all related to, directed at RA. RA is the party that actually directed and controlled every single aspect of this excavation. FDB didn't
But
pay.
he's still your expert that said, that made, he's the one that commented, or certainly one of the people that commented about the fact that the foundation wall was constructed during an era when footings did not incorporate steel reinforcing bars to transfer the weight across the cold joints. Basically, I mean, it was not unforeseeable that this could happen with this particular building.
I think again, with respect.
And it was your expert that said that.
With respect to FDB and Pavlak, it was unforeseeable. These experienced contractors had never seen anything like this. Only Mr. Spivey, who was very particular, he specifically said this was RA's, it was foreseeable to RA. They should have seen it. They were the ones that controlled everything. They were the ones that were on site. They were the ones telling plaintiff what to do and how to do it. My client didn't. We were basically told by RA what to do and how to do it and when to do it. That was part of their contract. That was part of what we had to do. We had to follow every single thing that RA did. They were the ones that told us what to do. They were the ones that were the experts that could have foreseen this. RNC,
So you have a third-party action against RA,
yes,
right?
But RNC could not have foreseen this. Our witnesses testified we had never seen anything like this. This was a latent defect that we could not have foreseen. At the very least, Your Honor, I think it's a question of fact. But if I could go to the one issue that is part of my appeal, Your Honor, with respect to plaintiff's lost wage claims. According to Balbuena and this court's decision in Mercado, when the employer presents evidence that fraudulent documents were submitted to gain employment.
Except that there's the witness from the company said that he started work in 2010 and that they relied on certain documents he produced at that time, but in fact, he had started working 10 years before, and I didn't see anything that rebutted that. So it seems to me we have a problem.
We have no, honestly, Your Honor, we have no evidence. We have no documentation.
You don't know when you started you don't know when he was employed?
No, because most of the documents that he has submitted that were part of the notice to admit were from various different companies. They were not from RNC. So he claimed that he started working and was paid cash in 2001, but the only time that we know is that in 2010, when we requested documentation from him, he produced a permanent
But
resident.
isn't that an issue of fact that would preclude summary judgment, at least at this stage of the case?
I don't believe so, Your Honor, because
Why?
in 2010, when we requested the documentation.
But if he says...
Request documentation, it's another thing to actually show that at the time the documents were requested, that was the beginning of the employment relationship. So you only showed one part of the puzzle.
Your Honor, I don't believe Balbuena has ever held that. I dispute that he started
So at the
working.
time of procuring employment, so that it's not just that documents requested, you'd have to show that documents requested at the time employment began.
Your Honor, that's when we know that the employment relationship began.
But there's a question of fact, because he testified that he was had been employed by that company for 10 years, and you didn't put in anything to rebut that. So why isn't that a question of fact that precludes summary judgment?
Because, Your Honor, when the documentation is requested.
That's not what, I'm sorry, I think you're misreading the statute. What I think the statute requires is that the company relied on the documents that were produced, but he says that he was not requested to produce any documents when his employment began 10 years before. So I don't understand, I'm having trouble with understanding how you rebutted
saying that he was.
And I'd really prefer that you not interrupt me.
Yes, Your Honor.
Now you may answer.
Even if you accept that he started employment in 2001, he started working. There were numerous documents in the record that he worked for in various different companies before 2010 when we asked him to submit the documentation. And at that time, he submitted fraudulent papers.
Thank you.
Counsel, I have one question. What is the safety device that you claim should have been used to prevent this accident?
According to the plaintiff's expert, it should have been, as was submitted to the DOB, which would have been a metal brace over the caul joint which would have prevented that from falling into the pit. Even the defendant's expert said that he doesn't dispute that that would have been an appropriate safety device. He said that they should have made the width of the pit smaller, and if that would have happened, then when this piece of cement dislodged, it wouldn't have fallen and struck in the plaintiff. That's specifically what the defendant said.
How do you address counsel's argument that your client submitted fraudulent documents?
I think it's a clear question of fact.
Well, is he disputing that that's what I'm trying to figure out. Is he disputing that the documents are fraudulent? I mean, he testified, I gave some guy $300 and I got a Social Security card. He's not disputing that the documents are fraudulent, correct?
He's not disputing that, but in the record, he got the documents from Oswaldo, who is a supervisor at the company, who told him that the company could help the workers, including the plaintiff, obtain the necessary document to continue employment, and relying upon that, as other workers did, he obtained those documents through Oswaldo. If I could just stress one really quick point.
No, it's okay. We're familiar with the record. Thank you.
Thank you.
Well, go ahead.
Could you just make that last point you were going to make?
I'm sorry?
Could you just make the last point you were going to make?
Yeah, as quick as possible,
Yes.
I will. On the argument that the defendants make that this dislodgement of the concrete was foreseeable only to third-party defendant, but not the labor law defendants, the GC and the
Right.
owner, that is incorrect as a matter of law. They have a non-delegable duty, that's number one. And number two, this court has made clear that the foreseeability element in the Chiariella case, the 2024 case, is not akin to foreseeability and negligence. It's not notice, it's not constructive notice, it's not actual notice. What the court said in that case is you just have to show that it's foreseeable that the task being performed would subject the worker to an elevation-related risk, and that's simply it. So it's incorrect. Thank you.
Thank you.
Your Honor, the question about the braces that are used for a permanent structure are not enumerated safety devices under 240. This is a permanent, if this lectern were the building, this building is taken down, this is now a permanent wall, which has been there. He's digging at the ground level under the foundation. There is no notice to the owner or the general contractor about the condition of the wall whatsoever.
Well, what about those experts that talk about all the foreseeable problems with that particular wall because of the cold joints, what we just said, which was what Mr. Spivey said? I mean, how can you say it's not foreseeable?
Your Honor, I take Mr. Spivey's expert affidavit in this context, which is he is talking about the means and methods of the work and the responsibility of RA in identifying this situation. At the time that this work was underway, it was not foreseeable to any of the party defendants in this case. Just by looking at it, you cannot determine this is a compromise.
But if there's isn't plaintiff correct that you have a non-delegable duty here, and if there's a problem, even if it turns out it was somebody else's negligence or fault, you'll pass it along to them later on in the case. But how do you get out of the case at this stage?
Your Honor, I agree with that. But I think when we're talking about the 240 claim, what we're protecting a worker from is him falling or something falling from above him that's either being hoisted or there's work being done above him that's going to cause something to drop. Not the fact that he's working near a permanent wall of an adjoining building.
Thank you.
Your Honor, Justice Scarpula, if I could just piggyback off to what your last question on the issue of lost wages. With respect to what plaintiff's counsel said is that he came back after the motion in response to what Ms. Lee put in her affidavit. Again, there's no debate that the documents were fraudulent. He claimed in his affidavit that the person that he testified to, that he identified as the Mexican, was actually a guy named Oswaldo, who he then said was a supervisor, and essentially trying to equate this to the Carroll case, where the employer did get them the fraudulent documents. And here, Your Honor, again, this is all hearsay. This is what a person named Oswaldo told him. But
No, it's him. It's his testimony. That's not hearsay. That's direct testimony. And you might not believe it, and he might be a liar, but it certainly isn't summary judgment material.
But it's his testimony as to what Oswaldo told
Yes,
him.
but what Oswaldo told him was, as he described it, on behalf of Oswaldo's employer, namely your client. So then it's an admission by the party.
Okay, but
So
if,
then it's not hearsay, counsel.
if you are going to rely upon hearsay,
And it's
well,
not
it's an
hearsay, I'm
exception to
sorry,
the
it's
hearsay
not
rule.
hearsay if it is on behalf of his client.
It's an exception to the hearsay rule.
Yeah,
Right.
yes, and therefore it is not hearsay.
But, Your Honor, before you can even rely upon hearsay, there have to be,
There is no hearsay what we're talking about. He's talking about a conversation he had with Mr. Oswaldo in which Mr. Oswaldo was speaking on behalf of his client, who was one of the parties here. So it's not hearsay.
So why isn't there an exception to the hearsay?
because, Your Honor, one, it's based upon a feigned affidavit because it contradicts his prior sworn testimony. Therefore, it should have been thrown out. That argument was made in the Supreme Court. That argument was made here.
And what happens if we don't find that it's contrary to his prior testimony? Do you have another argument?
Your Honor,
That's your argument, that
that's
if it's
our argument.
feigned so that, okay.
Yes, it contradicted his sworn testimony, and that's never been disputed.
Okay, thank you. Well, that's for us to decide, but, yeah. Henk Lane versus Stallard Management.
Good afternoon, Your Honors. My name is George Pallas. I represent the appellate, Henk Lane. There are three primary issues that I'd like to discuss with you in the few moments that I have. First, the issue that's presented to this panel is whether the change order requests that are an issue are a hindrance governed by section paragraph 15 of the contract. That's a no damage for delay that includes hindrances and obstructions, or is the change order requests include extra work or additional work that's covered by section 16, which states specifically that there's an alteration or a deviation or a modification to the work in any way.
Let me ask you something.
Yes,
The
Your Honor.
clause says, it's pretty broad as far as delay damages go, and it says, if hindered or delayed by Stallard or by changes in the work. So for you to win, you'd have to show that client was not hindered or delayed either by Stallard or by changes in the work. So how did you not fit into, this work not fit into one of those two categories?
Because when you look at paragraph 16, dealing with the changes provision, it also says specifically that if any additions, alterations, or deviations in the contract result in the performance of extra work, that's compensable to the contractor. So just so we're clear, when we talk about delay, these aren't delay damages. Delay is when a project
That's your
is extended.
argument. That's the whole,
Well,
that's
well,
your argument that it's not delay damages.
No, it's good, just 'cause we're using words, we're conflating words. Delay in construction refers to a contract duration being extended. That's not what we're talking about here. The delay clause in this case, no damage for delay, includes delays as well as hindrances and obstructions. So what we're talking about is events that occurred in the field that created according to the respondent, a hindrance, and the trial court accepted that, and the result of a hindrance, therefore you've waived your claim for compensable damages. The distinction that was missed by the trial court is that if there is an alteration, a deviation, a change in the work that requires the contractor to perform additional work, that's compensable.
But isn't that exactly what I'm trying to come to terms with? Is when you look at the delay clause, it says that it applies if plaintiff is hindered or delayed by changes in the work. So that's what the delay clause says.
No, but it does say that, Your Honor.
But
However,
we shouldn't apply that?
No. There's a conflict. That's what I'm trying to point out. You have to review both those provisions. The changes provision. Was there an alteration, deviation, or an addition? And what
You're saying if it was a change in the work, but it was an alteration, delay, alteration or addition, then that change language doesn't apply. It's
I'll give you the example, Your Honor, which I think makes it clear. There wasn't an analogy I provided in the papers, but I'll use one that's in this courtroom. If you were to hire me as a contractor to install this ceiling, and I would come in, I'd give you a price for $1 million, I'd open the two doors, I'd come in with my equipment, I'd roll it in place, and I would mount it. Okay, that's easy. I'm obligated to put the ceiling in. But if I show up on the day that I'm going to install the ceiling, but you decide, you know what, I'm going to dig out this entire floor. It's now going to be a cavity 14 feet deep because I'm going to do some underground work. But you're compelling me to install that ceiling. I still have to install it. But now I have to bring rigging. I need to put a temporary floor in.
So then, counsel, how do you deal with plaintiffs shall be solely responsible for the means, methods, sequences, and techniques of construction, provided that plaintiff shall not use that are likely, so this puts on you, 100% on you. If you have to disassemble or do something, it's on you. And the only remedy in that circumstance is to say, I need more time to get the work done. That's what you signed up for.
With all due respect, that language that you just so quoted is in every single contract for construction.
It doesn't matter. You sign that contract, it says what it says, and you cannot ignore it.
I'm not ignoring it.
Well, how do you ignore it? How do you get around that?
We get around it because the conditions that were in place in the field, the conditions that created the contractor to perform tremendous amount of additional work. In the example that I gave about the ceiling, the contractor did not contemplate sticking in steel joists on the floor to work over a cavity that's 14 feet deep. All of those extra costs of material and labor that I have to incur was not contemplated at the time of the subcontract.
How do you get around with, in addition, plaintiff's work includes everything required to provide complete installation, whether specifically shown or not. I mean, this covers them every single possible way for every single thing that you are arguing right now. How can you get around all 10 of those?
Because the change provision in paragraph 16 specifically calls out, specifically, if there are alterations, deviations, or additions. In my example, there are deviations.
No,
There's
let's talk about what you did. You said it took us extra time because we had to disassemble a piece of equipment and reassemble it, right? How is that not covered by all those things that I just literally just read to you?
Because the reason why we had to incur additional rigging, because in my contract, we excluded rigging, meaning no tower crane. We gave them a price. We'll pay for the tower crane for $100,000 as an alternate. They say, we don't want it, we'll provide the tower crane. We rely on that. Then the tower crane goes up, then they take it away. So as a result of that, I now have to add rigging, which was specifically discussed, negotiated with. And now all of a sudden, without that rigging in place, I now have to.
Specifically discussed but not excluded is in writing, correct?
It is in writing. The exclusion of rigging from Henk Lane's contract is specifically excluded. The consequence then, Your Honor, is that there's no rigging, a breach of contract by the respondent. The result of that is that these units that we were going to install had to be disassembled into multiple parts, 3 or 4 parts. All of that.
That's $67,000, the rigging. I'm looking at change order 41R1, disassembling HVAC units. That has nothing to do with rigging.
It does.
I'm looking at.
It does, Your Honor, with all due respect. It dealt with the.
Please don't interrupt me, counsel.
I'm sorry, Your Honor.
I want to hear what you have to say. I know, we're both excited. We're both excited.
I apologize,
right?
Your Honor.
No, and I understand. 116,000, coordinating, drafting, coordination drawing, surveying. That's one of the things you're seeking payment for. Duct work. Most of it has nothing to do with rigging.
Okay, so let me address the one you talk about, surveying. Post-contract, they issue 4 bulletins to the scope of work, dramatically revising the entire scope of work. As a consequence, we have to go back and resurvey and re-prepare the shop drawings, all of which was not contemplated at the time of contract. We already did it, we had to do it again. So it's extra work, compensable under paragraph 16. With respect to the orientation of the fan blowers, the contract said, have them discharge up. We buy exactly what they tell us to buy. I'm going
to let you finish up on rebuttal, okay?
Okay.
Thank you.
Okay, thank you, Your Honor.
Good afternoon, Your Honors. My name is Alan Winkler. I represent the respondent, Stallard Management. This case concerns 8 claims for additional compensation totaling about $2.5 million on a $9 million contract.
Counsel, can you address the interplay between the no damages for delay clause, which clearly excludes changes in the work, and the clause that counsel is referring to about changes? And so how do those 2 clauses interact with each other?
The changes clause applies to actual changes. The no damage for delay clause applies to costs for additional time to perform the scope of work.
So aren't they arguing that this is not just additional time claims, it's additional work, and that the changes clause should apply rather than the no damage or delay? What's your response to that?
They make that argument to get around the no damage for delay clause.
Right, so why are they wrong?
Because for one reason, their own corporate designee testified at his deposition that every one of these 7 claims, because there's one claim that's different, every one of these 7 claims is either due to resequencing the job, which is an element of delay in which the owner had the right to do under the contract, or a delay in the work, or inefficiency. If you look at the claims themselves, each one has only one cost involved, and it's called gang days, which is kind of like an antiquated term, but apparently they use that. And what it means is that instead of taking 100 hours divided by 4 workers to do, they used 8 workers, and it turned out to be 250 hours to do the work. That's another reason. Another reason, very basically, is that the work is the same. They have a claim for installing air handling units. They were the same air handling units that they had to put in all along. They have a claim for moving fans, the same fans that they were going to put in all along. They have a claim that, well, it was more difficult to put in the flue. Well, it's the same flue, put in the same place, and it just turned out to be more time-consuming than they envisioned. Same thing with the ductwork, and the same thing with the tower cooling piping. So it's not. What we're talking about is really an inefficiency because they took more time to do this than they anticipated, and Carino Savetta, and this is another part of their argument. They argue that the no damage for delay clause applies only to duration, but that's black letter law for 40 years or so. Not so. Carino Savetta, which I quote on page 33 of my brief, that part of Carino Savetta says a delay claim involves time, whether you spent more time to do the work within the contract period or whether you spent beyond the contract period to do the work. It's a delay claim. And in fact, even...
Can I interrupt you for a second? Doesn't it also say uncontemplated delays? Why isn't this not an uncontemplated delay? Because there are several clauses in the contract that's because a contemplated delay is defined, among other things, as something that's mentioned in the contract, a possibility that could arise in the contract. Well, the contract says that these drawings are not final, that they're kind of schematic, and they're subject to change. The contract says that you may have to store your materials in a designated storage area, which necessarily means moving. If you take away the rigging, why isn't that uncontemplated?
I'm sorry.
If you remove the rigging, as counsel just mentioned, why is that uncontemplated?
So I quoted on page 6 of my brief, Article 1C of the agreement, and it says right there, rigging is included. And not only that, but 38R3, their claim is for additional rigging. Well, if your claim is for additional rigging, meaning you had to do more rigging than anticipated, it means that some rigging was included.
So it wasn't uncontemplated.
Correct, because it's mentioned in the contract. That's the argument for, well, I think it's more than an argument, but that's my response. Thank you.
Thank you very much.
Thank you. I appreciate the time.
Even if the court were to conclude that these clauses preclude the recovery, then you need to go to the second element of analysis, which is whether the prevention doctrine stops this. Because the no damage for delay clause is an exculpatory clause. If you do not apply and consider the prevention doctrine, then you're essentially saying that an upper tier contractor or owner can do whatever they want to hinder, stop, impede, interfere with a contractor's performance at no financial consequence. And if you look at the governing policies behind the prevention doctrine, it is absolutely, this court has ruled in multiple cases that it's a variant of the good faith and fair dealing. You have to consider it. If you get past that and you say the prevention doctrine does not apply, you then have, the court should have looked at each of the 7 individual claims under the exceptions of the Carino-Civetta case. And there are multiple exceptions, including they do not get the benefit of a no damage or delay clause, the exculpatory clause, if the damage is caused by their reckless indifference, gross negligence, or there's uncontemplated delays, and or there is some other unforeseen conditions. They're all articulated. And each one of those is a factual dispute, because in this case, and I'll leave you with this, unless you have any questions, of course, I'll leave you with this. The example that I gave in my brief about me as a truck driver having to deliver the equipment to that building on this road, and then the owner builds a moat around it, I still have to deliver the equipment.
Thank you very
and then
much,
I got to build the
Thank
bridge.
you.
Thank you, Your Honor. Thank you very much, everyone.
Sanchez versus New York City Medical Practice.
Good afternoon, Your Honors. Joshua Lurie from Shapiro-Crowlin on behalf of the appellant defendant. This is a very simple and straightforward appeal. The trial court denied a motion to compel arbitration. Basis for it was of a lack of authenticity of the contract. Specifically, the court relied upon this court's decision in Knight. We believe that that was an improper application. The Knight court related to an allegation of a
And also that was overturned on appeal, right? The Court of Appeals just reversed.
I got to be honest, Your Honor, I didn't even note that the court has overturned that. Ultimately, that goes more towards the weight of this. But ultimately, in any event, this was a business record. It was presented. The question as to whether or not it was executed was never truly addressed. There was a challenge as to by the respondent plaintiff that she did not recall and that she did not speak English. But ultimately, the work was performed pursuant to the terms of the contract. We believe that the court inappropriately granted this permanent stay of arbitration, which is an extreme result for the court, and forced us into the trial court. We believe that arbitration should have been compelled. Unless there's any questions from the court, that's really all that I needed to say.
Thank you very much.
Thank you.
Good afternoon, Your Honors. James Ford for the plaintiff, respondent Sanchez. Excuse me. I think the court below properly held that the defendant did not establish its primary showing that a valid agreement existed at all. But even more importantly, just from a procedural standpoint, their motion was supported by an attorney's affirmation. There was no affirmation ever submitted by a person with knowledge.
Why is any other affirmation needed when it's documentary evidence? The document, which is the agreement to arbitrate, was attached. And the court is able to review that agreement.
They would have the burden of proving that the execution of the document, how it was done, when they eventually got around to submitting an affirmation only in reply. It was from a person who had no specific knowledge about what happened, didn't know this patient. He was talking about customs and practices that this place would use.
So we've held in Kappa versus Westchester Medical Group that you don't need an affidavit of someone with personal knowledge. This is under the technology law, right? And under the technology law, you don't have to authenticate an electronic signature, and that was exactly what Knight in the Court of Appeals said. And so this was put in as a business record under the technology law. Your client never denied signing it. She just said she couldn't remember, right?
Well, she said she didn't recall signing it. And
exactly. So she didn't say, I didn't sign it. She said, I didn't recall signing it, which is a lot different, correct? Correct. And so assuming that it came in as a proper business record under the Court of Appeals case last year and under the technology law, what did she put in to raise an issue of fact? Let's assume that it was properly authenticated.
They would have.
No, I'm asking you. I'm saying let's assume they met their burden. What did you put in opposition to raise an issue of fact?
In opposition, we raised the question of fact that she could never have made a knowing waiver of a constitutional right because of the fact that she could not speak English.
Okay, we've
Nothing was
addressed that,
explained
though,
to her.
before, haven't we? We've addressed that argument before many times. right?
Yes, Judge, but the point is, under these particular circumstances, they did not show that they made any effort to make sure that this woman understood that she was waiving a constitutional right.
But you don't dispute that wouldn't it be fair to say that after this incident, when the document was signed in some way, that she acted as if she then had a contract with them, in the sense that she then paid them the money that was due under the contract and then showed up to have the surgery and paid the additional amount that was due? So isn't that an admission on her part that she signed a contract that resulted in the surgery being done?
No, I don't think that's a fair assumption, Your Honor, because the point is that in this day and age, people who go to a doctor's office that don't speak English, they're handed a sheaf of documents to sign, consents to sign, and it doesn't mean that just because they eventually have a medical procedure done, that they consented to or had a knowing waiver of a constitutional right.
Isn't it true that there was a Spanish-speaking person that explained the document to your client?
No, there were Spanish people. I do recall that there was a Spanish.
Ms. Martinez?
There was a Spanish-speaking person there, but there was no indication that these documents were explained to her.
Did your client say that?
No, she said she did not. She had no recollection of this.
Recollection, right.
Yes, no recollection of these.
She did not specifically reject the notion that she was paired with a Spanish-speaking person with regard to this document.
No.
Thank you very much.
Thank you.
Stallard versus New York City Police Department.
May it please the court. Good afternoon. My name is Brian Stapleton. I represent the petitioner appellant Jay Stallard in this matter. New York's good moral character requirement, when applied in the connection of a firearm application permit denial, is valid only when applied to the application in a limited manner.
So why shouldn't we just remand the matter of this case, since the city has consented to a remand to reevaluate the case based on the new standards from the Supreme Court? Why shouldn't we just remand it and let that go forth?
Your Honor, petitioner appellant does not wish to have the case remanded because he's been fighting this issue for 5 years now.
But why wouldn't it be appropriate for us, especially since the city is consenting to a remand, why wouldn't it be appropriate, not what he wants, I know he wants his license, but why wouldn't it be appropriate for us as a court to give the court below a chance to reevaluate the issue, or for the case to be reevaluated based on clearly new standards articulated by the Supreme Court?
Well, Your Honor, the law is evolving and has done so rapidly in a very short period of time. However, petitioner appellant submits that the law, as stated in Antonia versus James, is very, very clear. Denial decisions based on the character requirement must be limited decisions. And while there is discretion embedded into the character requirement, it's very limited or weak discretion.
Well, don't we usually in Article 78 proceedings, we defer to the administrative agency that has the expertise in this area? If the administrative agency, or in this case, the police department, wants to take another look at it to make a determination based upon the new legislation and the new case law that, as you say, has been developing quickly, why should we not let them do that? And then you can come again here to an Article 78 if you don't like their determination at that time.
I understand your question, Your Honor. The petitioner appellant submits that this case is ripe for a decision right now. The law is clear as to the standards to be applied when using the character requirement. The facts of this case, such as they are sparse. And I don't know that a remand is going to make those facts more developed. We have 3 incidents that form the basis of the decision. 2 of them are now 14 years old. The only evidence which supports those decisions are unsworn statements containing hearsay allegations. I don't know what a remand is going to do.
Right, but in administrative determinations, they're allowed to consider hearsay in reaching their determination. So that's admissible in an administrative hearing.
Judge, it's true that the rules of evidence are relaxed during administrative procedures. However, there still must be the modicum of reliability for any evidence to form a basis of the constitutional proportions that are at issue in this case. We submit, petitioner appellant respectfully submits, that a remand cannot solve the problems that are baked into this case. That being, as I said before, we have 2 DIRs that are not even signed. They contain, they're rife with hearsay allegations. And we have a third incident that happens in 2021. That incident was thoroughly investigated. That incident was investigated by the New York Office of Family and Child Services. And the conclusion that was drawn after interviewing all of the parties involved, the petitioner, his daughter, his daughter's mother, was that these allegations did not they were unfounded and did not rise to the level of physical threat or imminent harm. The crucial analysis when looking at an application for a firearm is, do the facts rise to the level that the licensing authority can conclude with sufficient proof that the applicant demonstrates a future threat of harm or is untrustworthy to carry a firearm? Now, in these instances, both the 2011 instances as well as the 2021 instance, there was no firearm involved. There was no firearm.
Let's hear from,
Thank you very much, Your Honors.
Good afternoon, and may it please the court, Rebecca Viscatus for the respondent. As Your Honors have recognized, the city is consenting to a remand in this case. While the License Division rationally denied Stallard's application based on concerns that he would endanger others if approved to possess a firearm, and that rationale is one that this court has repeatedly endorsed, we recognize
So let me also say, right, he never disclosed the domestic violence incidents, correct? He didn't tell anybody about them when he applied for the license.
That's correct.
And that was part of the reason why he was denied a license. So if we looked at it right now, it wouldn't be arbitrary and capricious, particularly since the Supreme Court has recently said someone who has a history of domestic violence can be denied a license permit. That wouldn't be arbitrary and capricious to say, well, he never told us about those 3 domestic, and one is not very old, it's a year ago, right? And then the second thing was the domestic violence incidents. Again, the Supreme Court just said one may be denied a license based on a history of domestic violence. So if we didn't remand, your position is we'd have plenty of authority to say this was rational, correct?
That's correct.
But remanding will give you an opportunity to relook at this with respect to, I think it's Ramini, and
Antoniuk, yes.
Yeah, right? Doesn't that make sense?
I submit that it does, Your Honor. And it also gives Stallard the opportunity, if he believes that there is information that is favorable to him and that would change this determination, especially in light of that recent case law, then he has the opportunity to submit that. But overall, while we believe that this was a rational determination under both the standard as previously described and as recently framed by the Supreme Court in the Second Circuit, we think that it makes sense with this shifting landscape to remand so that there is no question about what standard the License Division has applied in evaluating Stallard's application.
Thank you.
Thank you, Your Honors.
Brit versus MTA? Oh, you didn't ask for rebuttal.
No, that's okay, that's fine. Thank you, nothing further, thank you.
Good afternoon.
Good afternoon.
Greg Laufer on behalf of the appellants, the New York City Transit Authority and the MTA. I'll refer to them collectively as the MTA. The plaintiffs here are suing under the New York City human rights law. They're asking the trial court for an order directing the MTA to provide identical discount fares for paratransit trips as compared to fixed route trips. The MTA moved to dismiss that claim on preemption grounds. Both federal and state, and the Supreme Court denied the motion. That was incorrect. That ruling should be reversed. Let me start with federal preemption. The relevant federal law here is the ADA and the federal regulations put in place by the Department of Transportation that implement that statute. And the ADA and those regulations clearly say that paratransit fares have to be no more than comparable. That's the key word, vis-a-vis fixed route fares. Not the same, not identical, just comparable. And those same federal statutes and regulations also say that comparable fares for paratransit can be twice as much as fares for fixed route, exclusive of discounts.
Counsel, let me ask you something with respect to the federal preemption.
Yes.
Under the obstacle preemption analysis, which is your argument under the federal preemption, it's required that you show that the two acts are in conflict with each other, the American with Disabilities Act and the New York City Human Rights Law, that they can't be reconciled. Why can't the two acts be reconciled? What about the statements in the federal act prohibit the MTA from offering identical discounts to the accessoride as they do to all other riders?
Thank you, Your Honor. Justice Kern, in fact, what the law says is that that is one type of preemption.
That's the one you're arguing, though, right?
We are arguing that there's federal field preemption, but the law does not say, and the Supreme Court has actually said this, you don't have to have incompatibility or total war between the federal and municipal or state laws. You can have that. There can be a direct conflict, but there can also be a frustration of purpose. And whereas here you have a federal statutory scheme with implementing regulations associated with that.
Wait 1 second. What would frustrate the application of the ADA by requiring people with disabilities to get the same treatment as in accessoride as they do if they went on the regular subway or on a bus?
Thank you,
what could possibly, how could that frustrate it? It seems to me like it would enhance it.
Thank you, Justice Scarpola. The answer is that Congress in the ADA and the Department of Transportation in the federal regulations implementing the statute said specifically that when a city or some other municipality has a fixed route service, it has to provide comparable service. And they actually specifically, the DOT specifically considered exactly what the plaintiffs are pursuing here.
That's the floor, right? Can't the city go and say, that's the floor, that's the least you get under the ADA, under the New York City?
And to add to that, doesn't the ADA specifically say that nothing in this section shall be construed as preventing a public entity from providing paratransit services at a level which is greater than the level of such services which are required under the section? So it's envisioning that there could be greater services and that it would not be any kind of conflict and consistent to have greater services.
Absolutely, Justice Kern. No one is saying that there couldn't be greater, but what you have here is specific regulations that actually address this particular issue. We're not saying that the New York City human rights law is upended or put aside.
Yes, you're saying it's preempted. That's exactly what you're saying. You're saying the ADA preempts the New York City human rights law. And specifically when there is a section that says, in the ADA, and plus cities, you can do better than what we're doing. What we're doing is a floor. I don't see how you can say that that's preemption.
We are saying it's preemption based on the claim asserted here. If you look at the prayer for relief in the plaintiff's own complaint, they are saying that the MTA is legally required to provide identical discount pricing for paratransit services. That is something that the ADA and the DOT already considered and rejected.
Well, they rejected it for the federal purposes, but there's nothing, where is there any indication in that act that they rejected a state from requiring greater services to be provided?
Well, because that's what they actually say. It says
They just say as to the federal system, that's the requirement. They don't say, where do they say that the state, where do they say that the states can't do more? And again, nothing in this chapter shall be construed to limit the remedies, rights, and procedures of the law of any political subdivision of any state that provides greater protection for the rights of individuals with disabilities and are afforded by this chapter. So it seems to actually envision that the states could provide greater rights, and there's no problem with that.
that's the key language, rights afforded by this chapter. There is no right afforded by this chapter, meaning of federal law, to identical discount rates. In fact, Congress and the Department of Transportation considered and rejected that. And if you look at the Arizona and Geyer
Isn't that a
decision,
very narrow way of interpreting this language, what you're suggesting?
no, it actually says a right afforded by, I think I'm actually interpreting the plain and unambiguous language. It says a right afforded by this chapter. There is no right that says thou shalt have this. It actually says quite the opposite. And the Arizona and Geyer decisions that we cited in our briefs from the Supreme Court, the United States Supreme Court, actually considered very similar circumstances, obviously different statutes, and reached the very same conclusion. Even if you don't agree with me, although I think you should, on federal preemption grounds, I'm happy to just finish my quick point. For all the reasons we've stated in our brief, we believe that state preemption also bars these claims under conflict and field preemption.
We shall let you address in rebuttal.
Thank
If
you.
we have more questions, once you address it, we'll keep asking.
Thank you, Your Honor.
Okay.
Good afternoon, Your Honors. May it please the Court. Anna Windemuth from Jenner and Block on behalf of plaintiffs' respondents. Appellants are asking this court to do something unprecedented, dismiss an anti-discrimination claim based on local law because it is supposedly preempted by federal and New York state law. But both the ADA and New York state law encourage localities like New York City to expand anti-discrimination protections beyond those afforded by federal and state legislation. That is why localities like New York City have historically enjoyed vast home rule power to legislate in the field of anti-discrimination. And that is why the trial court wholeheartedly agreed with plaintiffs that this case is not preempted. This court
Didn't we see that already in Center for Independence Disabled versus MTA? This very notion that we're playing over was discussed in a very thorough basis, and Judge Gish in that decision went through preemption. Obviously, it's a different section, and said that there's a difference between a floor and a ceiling. You can offer a certain amount of benefits, but that is not the ceiling.
Exactly, Your Honor. And I understand that Your Honor and the panel generally has particularly familiarity with the Center of Independence of the New York Disabled VMTA case. That's certainly right. This is the kind of, perhaps the rare appeal where this court has already expressly decided state law preemption on the exact same grounds that are at issue here. And
so let me read a quote. There is nothing in the transportation law indicating that defendants were to be exempted from any claim of disability discrimination, or that by complying with the requirements of the transportation law to substitute the particular law, they would be immune for all time from claims that the subway system discriminates against their protected class.
yes, exactly, Your Honor. So I think, certainly.
I'll yield the floor.
Yes, I think that's certainly correct. And so I think in terms of state law preemption, CID&Y basically resolves this appeal. I think just turning back to federal law preemption and the points that were made by opposing counsel, just wanted to note that it's very clear that the only form of federal preemption that defendants argue applies here is conflict preemption.
There was no field preemption on it.
Exactly, Your Honor. That's completely wrong. As Your Honors identified, there is nothing under the ADA that creates a conflict. And in fact, to the contrary, the statute over and over again makes it crystal clear that the statute merely sets minimum standards.
Is that the savings clause?
Yes, Your Honor, it's the savings clause, but there are also other aspects of the statute. So, for example, the statute says, and it empowers DOT to set minimum service criteria. So again, kind of clarifying that the ADA merely sets minimum standards. And also in a provision that's not addressed at all in defendant's briefing, the ADA says that nothing in this section shall be construed as preventing public entities from providing paratransit services at a greater level than or in addition to services required by the ADA. So again, it's crystal clear that the ADA merely sets minimum requirements. And I think just going to the point about the savings clause, I think Your Honor is correct that defendants really want to construe that provision in a way that's extremely narrow and that's just contrary to the plain text of the provision. And the full provision reads, nothing in this chapter shall be construed to invalidate or limit the remedies, rights, and procedures of any federal law or law of any state. So the phrase remedies, rights, and procedures of any federal law or law of the state is obviously extremely broad, and defendants' construction of that provision would essentially delete that language from the provision, which is obviously...
And there's nothing preventing the state from arguing that they have a legitimate non-discriminatory reason for requiring accessory to be more than a subway ride, right? They can argue whatever they want. It's just a question of whether you can even sue.
Exactly, Your Honor. That's precisely right. So that's, merits determination, and of course...
Has there been any merits determination of this case, or this was an initial attack on preemption and no other issue has been determined yet?
That's correct, Your Honor. Class certification is currently being briefed, and summary judgment has not been briefed or decided yet at this stage. So it's certainly a threshold question. It's just a matter of whether plaintiffs can even bring this action in the first place. As Your Honor's identified, the CID&Y case speaks directly to the state preemption law issue, so I think there's nothing to say on that point. And also on the federal law side, defendants have identified not a single case in which a court concluded that an anti-discrimination claim was preempted by the ADA. To the contrary, courts have time and time again recognized that the ADA allows localities like New York City to require more. Unless Your Honors have any further questions, plaintiffs respectfully ask the court to affirm the decision below.
Thank you.
Thank you, Your Honors. We are not saying that the New York City human rights law is bad. We are not promoting discrimination. All we are saying is that the issue here is whether federal and state law, or I should say federal or state law, preempt the New York City human rights law based on the plaintiff's allegations in this case. We are not asking for a broad sweeping ruling. It is clear that as framed, as alleged, the plaintiffs in this case are asking a court to essentially say, you MTA no longer have the discretion that was conferred on you by the state legislature. You no longer have the ability to do the very thing that the federal government has explicitly...
No. That's not what... They're saying that your different prices discriminates under the city human rights law. Let's assume that they meet their burden that is enough to allege a city human rights law claim, and then you go and you say we have a legitimate non-discriminatory reason for those fares, right? Isn't that the way it would go?
I do not think so, Your Honor. What the plaintiffs are asking for is an order from a court saying you MTA must stop discriminating.
That's relief. That's the relief they want, right?
Well, no,
right. And what their claim is that you're discriminating, and they're saying here's how I put it up. You're charging me this on here and this on there. I'm being treated in a different way in a different context. I mean, it's a pretty straightforward case. And then either you have a legitimate non-discriminatory reason, which I think you've articulated, which is it costs us more money to put together accessory, or you don't. I mean, I don't understand why that's so complicated.
I actually don't think it's complicated. I actually think it's very simple. The plaintiffs are, whether you characterize it as an allegation, may I finish answering? A claim or an allegation or a relief, what the plaintiffs are saying is at the end of the day, they want a court to direct the MTA to put in place discount fares that are exactly the same as the discounts available to fixed route
Based,
users.
based on their argument that your conduct otherwise is discriminatory. So it's not that they're trying to cabin your discretion in general, but they're saying that because you're discriminating in this case, you can't do that.
Right, and what we're saying is state law has already conferred on the MTA the sole discretion to decide that issue, subject to one exception, which is that the mayor is statutorily entitled to grant discounts, but that is the only exception that the state legislature has granted.
Thank you very much.
Thank you, Your Honors. I appreciate your time.
And the last case on the calendar today is People versus Lucant.
Good afternoon, Your Honors. Theodore Jack, Office of the Appellate Defender for Zachary Lucant. Zachary's use of what we acknowledge was really excessive corporal punishment cannot be separated from the extremely similar violent disciplinary practices his own parents normalized throughout his childhood. That context is critical not only to understanding why Zachary's sentence is excessive, but also his claim.
Because isn't there a waiver of the right to appeal in this case? So haven't you waived any argument about the excessive sentence?
No, Your Honor. If the waiver of the right to appeal was invalid here, if you look at pages 22 to 24 of the plea transcript, what you'll see is that the trial court basically says two diametrically opposing things about the appeal waiver, one after another. Before explaining what an appeal waiver is, the court tells Zachary that this thing it hasn't yet explained will apply even if he receives an enhanced sentence. But then when actually describing the appeal waiver, the court strongly implies the opposite, that it's only going to bar challenge to the promised sentence. The last thing Zachary heard from the court was that the waiver would preclude him from challenging the severity of a 2-year sentence. And counsel had not spoken to Zachary about the waiver prior to this virtual plea proceeding. All of this happens over video, and Zachary, who has never been through the criminal process in New York, who has never dealt with an appeal waiver, who has a documented history of learning difficulties, he did not understand. And on top of that, there's every reason to believe that the written waiver form used in this case, the one that Zachary supposedly reviewed in this brief conversation with trial counsel.
What do you mean supposedly? He says he reviewed it, and the court asks him, do you have any questions? Do you understand it? And he said, yes, I understand it, and I don't have any questions. It's not supposed, it's on the record.
Well, actually, Your Honor, what he says is there's no need to ask questions. This is someone who, he doesn't really see any option besides pleading guilty at this point, and he's just answering, what he has to. But the short...
What establishes that he doesn't mean what he's saying? You're essentially saying that he answered the question sort of by rote but that it didn't represent what he actually meant. Is that what you're saying?
What I'm saying is that trial counsel, again and again, if you look at the plea transcript, tried to rush through these proceedings. And even if there was a discussion with trial counsel about the appeal waiver form, that form was very, very likely invalid because it contained language that this court has recognized that respondent concedes was invalid. And furthermore, I just going back to the excessive sentence, what we're talking about is someone who has no predicates, who has showed commitment to rehabilitative programming, who completed parenting and anger management classes. For someone like that, 2 years, the court's initial promise was already pushing the boundaries of what was reasonable. And so even if some increase to Zachary's sentence was understandable when he failed to initially appear at sentencing, the place that the court...
He failed to appear for sentencing, right? He knew what he was getting, and then he failed to appear.
Exactly, Your Honor. And there's no question it was a significant mistake, a serious lapse in judgment. But what I'm arguing is that even if some increase to his sentence was reasonable under that circumstances, the place that the court ultimately landed, 3 years in prison and the maximum term of post-release supervision, that was far too severe. All of that...
So he severely beat his son.
Your Honor, we're absolutely not
and
trying...
He beat his child with a belt and a cord, right? His other children also had marks. And so I don't understand. He was subject to 2 and 7 years in prison, right?
Yes, Your Honor, that was the range.
And what was his sentence?
He received 3 years in prison.
1 year above the minimum, plus that 1 year above the minimum is after he didn't appear for sentencing, correct?
Yes, Your Honor. There's no...
So where is it that you're saying this was excessive? He got the minimum plus a consequence for not appearing for sentencing, right?
Your Honor, the excess is, you have to look at the context in which this
Looking
violence...
at the context, he severely beat his son.
That's
He
the...
got a minimum plus a consequence for not appearing at sentencing. How is that excessive?
Again, Your Honor, the context of intergenerational violence in which this crime occurred, this is someone who genuinely didn't understand that using that degree of force...
But the question is who should bear the brunt of the intergenerational violence? And the question is whether your client should, or whether the child does. And it seems to me that by his actions, he's saying, well, the child bears the brunt of whatever I had, whatever intergenerational trauma there was.
I don't think I'm saying that either of them should exclusively have to bear the brunt of anything. All I'm asking this court to do is look at the context in which this crime occurred, look at the fact that Zachary has already served 3 years in prison, and all we're effectively asking for at this point is a modest reduction in his term of post-release supervision.
Thank you.
Thank you.
Afternoon, ADA Nicole Nichols for the Office of Darcel D. Clark. May it please the court.
Counsel, is Mr. Lucant currently on his PRS?
Yes, Your Honor. He's already finished serving the term of incarceration, and he's on his PRS at this point. And we note that his PRS is subject to less is more. So to the extent that he got the 3 years, that would be reduced, provided that he exhibit proper behavior while on PRS. And we said the 3 years is reasonable in this case. More than, defendant only got that 3 years because of his conduct. He was initially promised 2 years. He then absconded. And for that, the judge increased the period by 1 year to 3. And I say defendant's conduct shows that this was a reasonable and warranted increase. Defendant's conduct here, as the court noted, was extremely serious. His son was 6 years old. He beat that child. The child was bloodied, bruised, and scarred. When the police showed up, allegedly 3 days after the last beating, the child's bruising was evident from his body. Defendant was shown pictures of his child, and he acknowledged that the scarring on the child's body was from his conduct. The fact that defendant may have suffered as a child was taken into account by the sentence that he received. He would not have gotten that sentence, the minimum that was promised, the 2 years, but for the fact that he had maybe had a difficult childhood himself. Defendant was 25, 27 at the time of sentencing. That's an adult. An adult should recognize, an adult who was 5'7", 230 pounds, should recognize that he should not beat his 6-year-old son to that extent. And I think the sentence he received here was eminently reasonable and fair, and no reduction is warranted.
What did he use? I believe it was a belt and a cord. Was that correct?
A belt and a cord. And he noted that his last belt broke on his son.
He had to use another one.
And he had to use another one. And he continued that. I think under the circumstances of this case, defendant's 2 years, 3 years, that was the result, again, of his own conduct. The fact that he absconded. And the judge, to the extent, told him if he absconded, he would suffer that. The court would not abide by its promised sentence and could increase it. And even though the prosecution asked for 4 years incarceration, the judge still exercised discretion and only increased by 1 year, the 3 years. I think defendant received an extremely lenient sentence. As to his arguments regarding the order of protection, the people would just note that this order of protection is made subject to family court modification. So defendant argues that he's not entitled to counsel before that, but that doesn't bar him from the right to go before family court and to make the argument that he has learned, that he has taken courses, that he hopefully has learned to parent differently, and that should be involved in his children's life. We do not know whether or not, what the family court has decided as the defendant, but he has that right to do that. And so we don't think there's any argument regarding that. And we note that the procedural bars that the waiver is valid and that defendant's other arguments is barred by that valid waiver. We would ask the court to affirm. Thank you.
There's no question that Zachary's conduct here was reprehensible. We're not trying to minimize that. But if I could touch briefly on the order of protection. I mean, we're talking about an order here that effectively terminates Zachary's parental rights.
Except that it's subject to family court order. And the family court can modify it and say that he can have whatever visitation family court deems appropriate, taking into account the best interests of the child, which family court will have the ability to obtain evidence about, which is not available to a criminal court judge. So why isn't this a reasonable solution, that he can go to family court and have the decision made in the child's best interest?
I mean, Your Honor, I think we have to look at the reality of the situation here, which is that the family court case is over. The kids have been placed back with their
Family
mother.
court case, he can go in and he can file a petition to modify the order of protection.
But
then it's not over.
As an indigent person, he has no right to counsel. And he has
Actually, that's not true. He does have a right to counsel on issues related to orders of protection.
But I believe as to where he is the petitioner seeking visitation, which is the circumstances under which the court said the order was modifiable, he does not have a right to counsel. And I just also add, I mean, this court in Crawford versus Alley just a few years ago noted that even for a temporary order of protection, where that order would affect a burden of parental rights or property rights, there had to be an evidentiary hearing. All we're asking in this case is for this court to remand so that the trial court can make those factual findings.
But why would it make more sense for that hearing to take place in the family court where they have the appropriate resources to do it?
I think that the legislature, in enacting CPL 53012, was very clear that criminal trial courts are just as well up to the task as family courts in making these sorts of findings. That's why they're required.
Thank you very much.
Thank you.
I'll go outside and break these guys. Whatever. You gonna stay here till I get out? Yeah.